Order 21. Execution of decree and order. Rule 1 to 106. When a court desires that a decree shall be executed by another court, it shall send to the other court a decree and certificate of non-satisfaction. Garnishing is a person who is debtor of the judgment debtor. Garnishing is judgment debtor's debtor, where the execution is applied within dash year of the decree. Issuance of notice and the application of the execution of decree to the judgment debtor is not necessary. 2 years of the decree, under which provision of CPC the execution of decree is specific performance for restitution of conjugal right and for injunction is provided under Order 21, Rule 32. A decree for the restitution of conjugal right can be executed under Order 21 of CPC, attachment of property. In India, a decree of restitution of conjugal right can be executed by attachment of property of the respondent. Execution of decree for a specific performance of restitution of conjugal right for the injunction is provided under CPC as under Order 21, Rule 32. A garnishing order under CPC issue to judgment debtor. Which one of the following provision of CPC provide the adjudication claim as the objection of attachment of property? Order 21, Rule 58. In execution of decree, other than decree maintainable salary of a person can be attached with the extent of 1,000 plus 2/3 of the remainder. Auction purchase shall pay full purchase money within 15 days. What is not material irregularity under Rule 90, Order 21 of CPC? Omission to record for adjournment of sale. Who is not entitled to apply under Rule 19, Order 21 of CPC for set aside sale of immovable property in the execution of decree? None of the above. Proceeding in the CPC include a proceeding for the execution of decree and order. Time prescribed for filing in which of the following cannot be extended condoned by the application provision of Section 5 of the Limitation Act. Application for the execution of Order 21 of CPC. Which one is not correctly matched? Issue of Commission Order 21. The present Section 5 of Limitation Act apply to all the application other than those under any provision of Order 21 of CPC if the applicant is satisfy the court that he had sufficient cause for not preferring the appeal or making application within such period. Order 21. Which one of the following is not file an application for execution under CPC, namely judgment debtor? Where immovable property from an estate situated within the local limit of jurisdiction for 2 or more court, any court may sell the entire estate. Where any property has attached in the execution of decree, the court for any reason passed an order dismissing the execution of application, but omit to give any direction as to attachment. Attachment shall be deemed to have ceased. After the passing of decree of the payment of money, On the application of the judgment debtor, court shall not order that the payment is amount to decree shall made by the installment without the consent of the decree holder. Order 21 of CPC dealing with the execution of decree and order contained in Rule 106. Largest order of CPC is Order 21. Decree of the restitution of conjugal right may be enforced by attachment of his property. Application for execution of decree is made to a court which passes the decree. A garnishing order is an order prohibiting the judgment debtor and debtor from making the payment of any judgment debtor, directing the decree holder to take the payment for the judgment and judgment debtor. Sale of immovable property in the execution of decree cannot order by court of small causes. A decree of restitution of conjugal right in India is executed by attachment of the property of the respondent. Money under the decree can be paid either in the court out of the court. Principles governing execution of decree and order of CPC dealt within Order Section 36 to 74 substantive and Order 21 procedural provision. X obtain a money decree against Y. In the execution of money decree of X, the attachment money belonging to Y lying with Z, then Z is called garnishing. The decree of restitution of conjugal right is enforceable under which of the following provision of CPC? Order 21, Rule 32. Garnishing means judgment debtor. Order 22. Death, marriage, insolvency of party. Rule 1 to 12. The death of the plaintiff and defendant shall not cause to the suit to abate if the right of the sue is survive. An application for the substitution of legal representative of the plaintiff who had died, he has to be moved by the legal representative of the plaintiff. Where the plaintiff die after hearing and before the pronouncement of judgment of suit shall not abate. Under CPC 1908, death of the either party of suit between the conclusion of the hearing and the pronouncement of the judgment, the suit shall not be abated. X died leaving behind the son Y and married daughter Z. A suit filed by X after his death can be continued by Y and Z both as a legal representative. If a right to survive, if a right to sue survive, will the suit to await the party of death? No. Where any party die after conclusion before the pronouncement of judgment, the suit shall not abate. Point out the correct answer. Under Civil Procedure Code, where any party after the conclusion and before pronouncement of judgment suit shall not be abated. During the period of conclusion of the hearing, the pronouncement of judgment, if either party die under Order 22 Rule 6 of CPC, the proceedings shall not abate irrespective of whether cause of action survive or not. An appeal under Order 43 of CPC shall lie from which one of the following order. Rule 9, Order 22, refusing to set aside and abate the dismissal of the suit. On abatement of suit under Order 22, Rule 9 of CPC, a fresh suit on the same cause of action is barred. Under CPC 1908, on the death of either party of suit after the conclusion of hearing of the pronouncement of judgment, the suit shall not abate. A pleader has a duty to inform the court about the death of the party. Order 22, Rule 10A of CPC. Where a suit is abated and dismissed under Order 22 of CPC, the same cause of action, no fresh suit shall be brought. Where a party die after conclusion of hearing before the pronouncement of judgment, the suit shall not be abated. Which one of the following statement is correct? Where on the death of the defendant, the right to sue survive against the other survival defendant along, the case may proceed against the surviving defendant. Where on the death of the defendant, the right to sue does not survive against the or other surviving defendant alone, the case shall abate against the deceased defendant if no application is made within the time limited law and the legal representative of deceased defendant to be made a party. There shall be no abatement of the reason of the death either party between the conclusion of the hearing and the pronouncement of the judgment. Where a suit abate the dismissal under the provision of Order 22 of CPC, then the second suit on the same cause of action, second suit cannot be instituted. To which one of the following case the provision of Order 22, Rule 3-4 of CPC apply? Execution proceeding. Abatement means suspension or termination of proceeding in any action for the want of proper party. For filing a application for an order to set aside an abatement, the period of limitation from the date of abatement is 60 days. Where a suit abate for dismissal under Order 22 of CPC, the same cause of action, no fresh suit shall be brought. Order 33. Withdrawal and adjustment of suit. Rule 1-4. Where a fresh suit is instituted on the strength of the permission granted by the court under Rule 3, Order 23, Rule 1, the plaintiff shall be bound by the law of limitation in the same manner as the first suit had not been instituted. Right to withdraw a suit is absolute right of the plaintiff. Mark the incorrect statement in relation of Order 23 of Code of Civil Procedure 1908. When there are several plaintiffs of the court can allow one of them to withdraw even if the other co-plaintiff do not consent with such withdrawal. Party to the suit to compromise the suit under Order 23, Rule 3 of CPC. The order noting compromise among the party as to pass under the provision Order 23, Rule 3 of CPC has to be in writing and duly signed with the respective parties. Compromise under Order 23, Rule 3 of CPC must be in writing and signed by the party. Under Order 23, Rule 3 of CPC is basic on the compromise. A decree has been drawn only in respect of subject matter that relate to the suit. Where a decree of compromise which is not lawful, there no suit shall be lie to set aside the decree. An agreement to compromise entered in the representative suit without the leave of the court is void. After withdrawal of the suit, a plaintiff cannot institute a fresh suit in respect of same subject matter unless liberty is given at the time of withdrawal of suit. Order 23 of CPC applies to the following: withdrawal of the suit. A suit filed in the respective capacity can withdraw, compromise and abandon etc. the plaintiff after the notice to all the person interested. Which one of the following statement is incorrect? Which one is correct? A representative suit may be instituted by one or more person from the benefit of all interested person with the permission of the court. Notice of the institution of representative suit must be given to the public advertisement at the plaintiff expenses all interested person where by reason of the number persons served is not reasonable and practicable. Any person in whose benefit the representative suit has been instituted may apply to join as a party thereto. Liberty of institution of fresh suit in respect of same subject matter. The time of withdrawal of the suit is given where the suit suffer from the same formal defect is likely to fall that account where the court finds the sufficient ground. Can a suit laid down after the withdrawal of the same? Yes, if the permission is obtained from the court at the time of withdrawal of suit, it is a liberty of the fresh suit.